You applied for a discharge upgrade and the board denied it. I've had clients in that situation and I know how you feel. But your case is not over and it's not final. And in this video, we're going to talk about the 5 options that you have after being denied a discharge upgrade from the DRB. At the very end, we're also going to talk about one issue that veterans often deal with that can be fixed easily. My name is Kevin Courtney. I'm an attorney here at the Courtney Military Law Group and a former Marine Corps officer and judge advocate. I help veterans upgrade their discharges and correct their military records so it accurately reflects the service that they gave to our country. A denial from the Discharge Review Board feels personal. It feels like it's a second attack on you despite your efforts to explain why that characterization no longer fits the bill. And so first, we got to look at why your case was denied. Was it in the right forum? Did you not have the right evidence? And then we're going to look at those different options that you have. So for example, if you apply to the DRB without an attorney, you can go back and ask for reconsideration if you retain counsel, who then presents your case in a way that the board can really understand. By reading that denial letter, the decisional document will actually explain the reasoning from the board for why it was denied. That can be really helpful because it shows the weaknesses in your case and where you can improve your case so that you have a better chance at getting the upgrade. There's a difference between having bad evidence or having a bad argument and simply not having the right evidence or the right argument. With the proper advice, veterans can re-petition that board and hopefully get a different answer. If you just file the same petition again, you're probably going to get denied and it's going to be a waste of your time. You have to be far more strategic and look at that document to figure out why it was denied first. Before you ask for reconsideration, you should also ask yourself if you have any new and material evidence that might relate to your case. For a lot of veterans, that's going to be medical or mental health records. And if you can present evidence that shows mental health symptoms contributed to the misconduct for which you were separated, the board is required to use liberal consideration when looking at your petition. I did a video here on liberal consideration if you want to check it out. The second option that veterans have is going to be asking for a personal appearance hearing. Assuming that you only did a document review for your first go around, you're entitled to have the Discharge Review Board have a personal appearance hearing for you in your case. In that case, you need to be prepared to answer questions, typically via Teams or Zoom, from the board members. They're going to ask you what's going on with your petition, what's going on with your life, and why are you deserving of a discharge upgrade. So if you've never done the personal appearance hearing, you're entitled to it and you can reapply by going back to the DRB, assuming you're within the 15-year window. Option 3 is going to be going to the Board for Correction of Military Records or the Board for Correction of Naval Records, depending on your service. These boards are going to be looking for errors and injustices. It sounds similar to the standards used at the DRB, but the Board for Correction of Military and Naval Records are looking to see if the military followed its own regulation, which would be an error if it didn't, or if the discharge that you have is an injustice based on the situation and based on the evidence that you've presented to them. One of the differences is that the BCNR and BCMR are staffed with civilian staff members, whereas the Discharge Review Board typically going to be military officers. So the takeaway is that the Discharge Review Board may have closed one door, but it opened a next door for you to go to the BCMR or BCNR. The fourth place that you can go if the BCNR or BCMR denies your petition is going to be the Department of Defense, DARB. The DARB is going to review the decisions from the various boards from the different services. The whole point of having a Department of Defense-wide board is to make sure that members of the Marine Corps, compared to the Air Force, compared to the Army, are all being treated the same way when it comes to the characterization of discharge. We don't want services having too hard of a standard or too light of a standard. DARB is able to level that playing field when it comes to discharge upgrades. But the DARB is one, far more technical because we're dealing with a document review only. So all of the arguments have to be made within the written petition as opposed to a personal appearance hearing because that's not going to be available at the DARB. The DARB is only available to veterans who were discharged after December of 2019. And there is a deadline to do this. Veterans have to apply within 1 year of the decision from the BCMR or BCNR. But even a denial at the DARB can lead to another open door. Number 5 is going to be going into federal court. Federal court is where a judge is going to review the evidence that was submitted to the Board for Correction of Military or Naval Records. And specifically, the judge is going to determine whether that entity complied with the law or acted in a way that is considered arbitrary and capricious. The big difference that veterans must understand here is that the judge is not going to supplement his or her personal views on your case. You might have a very empathetic case. You might be very deserving of a discharge upgrade, but the judge is going to look at whether the board complied with the law and has a reasoned explanation for why they denied the discharge. If the judge determines that the board failed to comply with the law, acted contrary to the evidence before it, the judge would often remand the case back to the board to comply with the law. The judge isn't necessarily going to be able to order a discharge upgrade directly to you. One of the big cases that came out of the Ninth Circuit recently was Boosie v. Driscoll. I've done a video on that here. You should take a look at it to see how federal courts are going to be applying the law of liberal consideration to discharge upgrade applications. Sometimes I talk to people who say, I was denied, I probably just deserve the discharge that I have. And the way I look at it is, I think everyone deserves a chance to appeal a decision if the evidence that they have supports their case and supports their argument. So many members that I've talked to served in a time period when they had a mental health issue that contributed to the misconduct for which they were discharged. And it is our obligation to make sure that your military record accurately reflects your service. It's not fair to label symptoms of mental health as misconduct, and these boards exist to correct those records and to fight the injustice. So those are the 5 options that veterans have: doing a reconsideration with counsel, asking for a personal appearance hearing, going to the Boards for Correction of Military Records, the DARB, and then finally going into federal court. The big mistake that I see veterans make is they ask for relief under the wrong argument. Sometimes they ask for relief under an error when it's really an injustice. Sometimes they're asking for an injustice and it's not there. One thing that sometimes will work is asking for clemency. If your next step is going to a Board for Correction of Military or Naval Records to upgrade your discharge, clemency may be the route for you. I did a video on clemency here if you want to continue watching.